So, hello, good afternoon, everyone, and welcome to today's session of the Hellenic Copyright Organization um, of the Copyright Global Talks. It's the webinar series organized by the Hellenic Copyright Organization. For those who join us for the first time, the Copyright Global Talks is our platform where for in-depth expert dialogue of the most pressing issues in copyright law and policy, bringing together academics, practitioners, and policymakers from across Europe and beyond. I am Maria Daphne Papadopoulou. I'm the acting director of the Hellenic Copyright Organization, and I'm very happy that I will host today's discussion. Today we turn our attention to a ruling that has been quite literally decades in the making. The Court of Justice judgment in case C-590-23, Pelham 2. A dispute that began with a 2-second drum loop sampled in 1997 has over more than 20 years produced some of the most consequential copyright jurisprudence to emerge from Luxembourg, reshaping our understanding of the reproduction right, the scope of exception, and the relationship between copyright and artistic freedom. With Pelham 2, the court has now attempted to give meaning to the concept of pastiche as an autonomous notion of EU law, a concept that is, as the court itself acknowledged, not devoid of ambiguity. The implications stretch well beyond sampling. They speak to remix culture, AI-generated stylistic imitation, and the broader question of how the exhaustive list of exceptions in the InfoSoc directive can accommodate the realistic of creative practice in the digital age. To guide us through this judgment, its reasoning, and its consequences, I'm honored to welcome Professor Bernd Jütte, that he is an associate professor in intellectual property law at UCD's Sutherland Schools of Law. Professor Jütte's research sits precisely at the intersection where today's discussion lives: digital copyright, the interplay between exceptions and fundamental rights, and the regulation of online speech through copyright norms. There are few people better placed to unpack what the court has done and what it has deliberately maybe left undone in this ruling. So, Professor Jütte, dear Justin, welcome, and the floor is yours.
Wonderful. Thank you very much, Daphne. I'm very happy to be here today on this Monday morning. I'd be much more happy to be in Greece this time, but it is as it is. I will also preface that this is, of course, as you mentioned, a ruling long in the making. It's been something that has more or less accompanied my entire academic career in the field of copyright law. And there is a likelihood that we can finally put a final chapter to the saga that started effectively in the early 2000s with the first case before the Landgericht Hamburg, so the regional court in Hamburg. And you already mentioned the basic problem, which is very, very simple, is that in 1997, a German music producer, a hip-hop music producer, Moses Pelham, took a 2-second sample and looped it throughout the duration of a song that he produced for a nowadays relatively unknown German artist, Sabrina Setlur, in the song Nur Mir. And he took the sample from an even more obscure, at least in my circles, electronic band, the band Kraftwerk. And this very, very simple act then sparked more than 20 years of litigation. And the first thing I want to do is, for those that aren't as old as I am, is to walk you a bit through the history of Metall auf Metall, or Pelham as we know the case nowadays, and the issues it has touched so far, and how we ended up at the point where we found ourselves now in March and April 2026. So when the case first came to the German courts, the initial question, which the Court of Justice would then answer many, many years later, effectively in 2019, was whether, or to what extent, or in which way, the right of phonogram producers had to be interpreted. The question was relatively simple. The sample is so short, 2 seconds, and it kind of like audibly gets lost in the new composition which is integrated. Under normal copyright standards, so if you were to consider the sample as an original work, it would be questionable whether this would constitute infringement. However, the German courts relatively early on took a position that saw any reproduction from a sound recording, whatever short, would constitute an infringement of the right of the phonogram producer. And this then took a number of years until the case worked its way up to the Federal Supreme Court. And in addition to this question on the interpretation of the phonogram producer's right, was the question whether an exception or a limitation existing back then under German copyright law, namely paragraph 24, paragraph 1 or subparagraph 1 of the German Copyright Act, would be an exception that could apply to this case. The exception was the so-called free use exemption that allowed a user of a work protected by copyright to use the work in a way, and I paraphrase now, that it fades behind the new creation. So it kind of like merges or organically integrates into the new creation. And this is important to keep in mind when we later on then come to the Court of Justice's ruling in Pelham number 1. After the Federal Supreme Court had established that any taking of a phonogram sample would constitute infringement, and in principle the free use exemption could apply, but it really is case dependent. The case went back to the lower courts. The case got a bit more complicated and eventually ended up before the German Federal Constitutional Court, namely on the question whether the way the German courts interpreted the phonogram producer's right, but also the free use exemption, would be reconcilable with German constitutional law. In different terms, whether the way the German courts interpreted copyright law is reconcilable with the freedom of the arts as interpreted by German constitutional law, or in the light of German constitutional law. Now, one thing that one has to add when someone was born significantly after I was born, that in the meantime something happened at European level, namely that the European legislator introduced in 2001 the Information Society Directive, which harmonized large aspects of German, but also the copyright law throughout the member states of the European Union, including the rights of phonogram producers, and with Article 5 of the Information Society Directive also exceptions and limitations, which then led the German Constitutional Court to say, in principle, we do not agree with the way the German civil courts had interpreted copyright law in the light of German constitutional fundamental or basic rights, but also in reviewing the case, the German Federal Supreme Court, so the German High Civil Court, should maybe ask the Court of Justice for assistance in interpreting German copyright law in the light of European fundamental rights, which of course apply the second we apply European Union law or national law that is harmonized by European Union law. So not only is this a case in basic copyright law, but also a wonderful textbook example of how European fundamental rights take effect at national level. And this was just a walk through effectively 15 years of litigation. Now, we find ourselves in the first Pelham iteration before the Court of Justice, where the Court of Justice was then asked by the German Federal Supreme Court two very important questions. The first important question was, how under European Union law do we have to interpret the right of phonogram producers? And there the Court of Justice slightly departed from the German interpretation that any taking of a sample from a sound recording triggers the phonogram producer's right and therefore constitutes infringement, unless an exception applies, of course, but stated instead that yes, in principle, even short reproductions constitute infringement of the phonogram producer's right, unless these reproductions as integrated into a new creation become unrecognizable to the ear, whatever that might mean. And the second question the German Federal Supreme Court had asked was whether, if no exception exists under national law that would permit a practice such as sampling, could domestic courts, in the light of fundamental rights, create exceptions simply based on a free balancing of fundamental rights? And there the Court of Justice said, for the sake of the effectiveness of European Union harmonization, this would be impossible, because the result would be that every member state could come up with their own copyright exception. And one should know that Article 5 of the Information Society Directive, which harmonizes large areas of copyright law, says that all the exceptions listed in Article 5 of the directive constitute an exhaustive list. So these are the exceptions member states can implement and no more. Which also led the Court of Justice to state that the free use exemption, paragraph 24, subparagraph 1 of the German Copyright Act, was not in accordance with European law, which meant the Germans had to omit this provision out of their copyright laws. So the court went back to Germany, and the Federal Supreme Court, and then later on the Hamburg Court, found that what Pelham had been doing effectively since 2001, after harmonization kicked in, was unlawful because the phonogram producer's right has to be interpreted still relatively strictly, and a free use exception does not apply, nor does any other exception that Germany had implemented apply to what Mr. Pelham had been doing. Interestingly, however, it said that before European law harmonized German copyright law, i.e. from 1997 to 2001, what Mr. Pelham had been doing, the sampling of a 2-second sample, constituted a lawful use because until 2001, it was covered by the free use limitation or exception.
But we are still talking about the Pelham one.
We are still. I'm coming
we
to
are
that.
still
I'm
Pelham
now
one.
moving on.
Okay.
Yeah, but I think it's important to have the background here.
Yes, but very interesting. There's some details that also I was not aware of. But is the first time that the ECJ, the Court of the European Court of Justice, mentioned this recognizability criterion? This is the first time.
That is the first in the Court of Justice used the term recognizability in relation to the interpretation of one of the exclusive rights. And I know why you asked the question. We'll come back to that later, because this seems to have now radiated into other areas of infringement tests. So we can also keep this in mind for the moment. Now I come to Pelham 2, because what happened in 2021 is that the German legislator introduced from Article 5, paragraph 3, letter K, the pastiche exception, which it earlier on had assumed would be included in this free use exception that the Court of Justice ruled to be incompatible with European law, which then triggered Pelham's lawyers to say what Mr. Pelham had been doing all the time was nothing else than a pastiche. The problem was that nobody knew what a pastiche was. The concept had been never really discussed in the literature. Its ordinary meaning differed between the member states, so there was a bit of legal uncertainty as to what constituted pastiche, and as a result, when the case then reached again the German Federal Supreme Court, that court referred the case to the Court of Justice of the European Union and asked, number one, what does pastiche mean? And could potentially pastiche be interpreted in a way that it constitutes a catch-all, so kind of a free, flexible norm that would be applicable to all types of artistic and other appropriation of existing works. And it also asked whether the making or the performance of a pastiche requires some form of a subjective element. And then we find ourselves in 2026 when the Court of Justice had to interpret this notion.
So what did the Court of Justice decide? And actually, did he... does the court's interpretation was of the pastiche differ from the one that then Advocate General gave?
Yeah, so the Advocate General delivered its opinion in 2025. Advocate General Emil, freshly coming back then from Cyprus, so it was a new Advocate General. And he wrote a very, very interesting opinion, essentially giving a relatively brief interpretation of what constitutes pastiche. And that slightly differed in minor but yet important elements. For example, the Advocate General stated that a pastiche, and there he based himself on the interpretation given by the Court of Justice to the notion of parody, is the use of a work in a recognizable yet different manner. So there must be similarity, but there must also be a clear difference between the original work and the work that uses this original work or part thereof. But it also required that, so the Advocate General, that the new creation adopts the aesthetic language of the original work. So it's relatively narrow and requires something of, which the Court of Justice would then substantiate, a dialogue between the original work and the work that uses this original work. And it also said whether something constitutes a pastiche has to be judged against a very specific person, namely one that is familiar with the work, but also possesses an intellectual understanding required to perceive the pastiche. And I really struggle what this means in practice. Fortunately,
I wanted to ask you, but maybe afterwards, what does the poet mean actually?
well, let's
The
ignore this
judge.
for the moment at least.
Yeah.
Because the Court of Justice delivered a much, much shorter judgment. And one thing that we should mention is that the Court of Justice usually answers question that is being asked. The Advocate General had a much more almost poetic assessment on the reconcilability of copyright law and the freedom of the arts. And this was the prism also through which the Court of Justice then provided its now authoritative interpretation of the term pastiche. It picked up many of the elements that the Advocate General had suggested. It said, yes, a pastiche is the use of a pre-existing work in a recognizable but fundamentally and substantially different way. So there must be recognizability, a term that is now moving into copyright law also in many, many other areas. But in doing so, it has to adopt certain characteristic elements of the original work. And this is something that would probably cause a number of issues. But it then also said that a pastiche does not require intention on the side of the person who creates this pastiche, but simply requires that the pastiche is recognizable as such by a person familiar with the original work. That means we can essentially avoid this discussion on the intellectual understanding required to perceive a pastiche, which is something I think would have been very difficult for the courts to handle. So after the ruling, and then we can also move into a deeper analysis, we have a definition of pastiche. Number one, it's not a catch-all clause. It's not a clause that can be flexibly appropriated, but there are a number of substantive criteria. Namely, we need the evocation of an existing work in a way that makes the new work noticeably different. So it's not a plagiarism or a blatant copy, but it has to alter the work in one way by using characteristic elements from the original work, by borrowing something of the original work that makes the original work the work that is effectively is. And in doing so, it has to enter into a creative or artistic dialogue with the original work. And that's an important criterion. Also a criterion that the Court of Justice seemingly borrowed from the interpretation given to the exception for the purposes of quotation. So we also have at least a terminological overlap between some of the exceptions that we find in Article 5, Paragraph 3 and Paragraph 2. But this is what we have for the moment. We have a relatively straight definition of what is pastiche, but of course there are also a number of elements that still make me scratch my head every now and then.
Okay, I want to ask you many questions, but just to say, because I start from the one thing that you mentioned lastly, you said about the quotation. So from what I understood is that the court declines to import the quotation exceptions proportionality requirement in this pastiche analysis. Does this create a structural inconsistency within Article 5, Paragraph 3? And could it lead to pastiche effectively swallow actually this quotation exception in creative context?
Okay, so I'll break down the answer into 2 points, and I'll start with the last one. So one thing the Court of Justice, but also the Advocate General did in their respective inputs into the case was to state that we have to be very, very careful to consider every exception by themselves within Article 5, but also within Article 5.3, letter K. To give you one example from the ruling of the Court of Justice, based its definition of pastiche on the notion of parody by stating we have in Article 5, Paragraph 3, letter K, parody, caricature, and pastiche as potential exceptions. And because we have 3 terms there that also systematically suggest that these terms are different. So we cannot interpret pastiche so broadly that it would swallow parody and caricature, or for that purpose, the quotation exception. So it also means we have to understand this notion of a dialogue in a different way, most likely, than the way it appears in the quotation exception, which talks of a in accordance with fair practice. So quotations can be made in accordance with fair practice, which effectively boils down to a quantitative but also qualitative proportionality test. You can only take as much as is necessary to perform the function of the quotation, i.e. to enter into a semantic dialogue with the original work. My guess is, and I have no authority for this, quite frankly, is that for pastiche, there is no limitation because there is a larger license to adaptive users in artistic contents. Quotation is not per se an artistic exception. Pastiche is, and this is why I think there is no systematic disconnect. I would even argue there is no systematic structure within Article 5. It is effectively, if you look into the history of Article 5, a potpourri of exceptions that existed before European harmonization in national laws. But I think the Court of Justice, because it examined the pastiche exceptions through the lens of artistic freedom, through the rights of the EU Charter, artistic freedom, freedom of expression, subjecting pastiche to a strict proportionality requirements in terms of quantity would have been difficult. So to put it in very, very simple terms, art is allowed to do more in terms of quality, but also in terms of quantity. And this is, of course, also relatively reflective in the case law of the European Court of Human Rights in Strasbourg, when we talk about artistic appropriation, not necessarily in relation to copyright law, but in relation to other rights that have to be balanced against the right to artistic freedom, privacy, religious feelings, and so on and so forth. So I think the Court of Justice simply gives artists a bigger and a better license to appropriate.
Yes, speaking of that, you mentioned also the Advocate General was very much, okay, he had a poetic, let's say, attitude towards this case. And he raised Article 13 for the freedom of the arts as a constitutional, actually, backstop.
Yeah.
But the court has, in a way, has sidestepped that question. Has the court, in this way, has left actually unresolved this tension between the exhaustive leave of exceptions and the charter tension that in one point inevitably will return in order in a future reference?
Yeah. Answering that question would probably take me 3 or 4 hours.
Yeah, okay.
But there are two things that one should keep in mind. And if you're not fully familiar, I know that you are, but not necessarily all the listeners, with the case of the Court of Justice that preceded Pelham. The Court of Justice had said in Pelham, Spiegel Online, and Funke Medien, all decided on the same day that European Union law will not accommodate an open norm, full flexibility, but the balancing of fundamental rights, including freedom of the arts, against, for example, proprietary interest, happen within the exceptions that we find in Article 5. So Article 5 determines, together with the exclusive rights, the balance between expressive freedoms and other fundamental rights and the right to property. I don't think the Court of Justice ignored the question. There are references to Article 13 in the ruling, but I think that there are two possibilities. Number one, within the College of Judges that rendered the decision, they couldn't agree, and everything they couldn't agree on, they didn't write into the ruling. This is how the Court of Justice works. There are no dissenting opinions. And a more simple answer could be that the Court of Justice thought that the flexibility provided with a pastiche exemption is sufficient to strike the balance between artistic freedom and proprietary interests of right holders. One thing that one also has to mention is that in principle, and this is an age-old discussion dating back to 2000, early 2000, that the list in Article 5 is exhaustive, but also member states do not have to implement all the exceptions that we find there. But since 2019, at least in certain contexts, pastiche, parody, and caricature, as well as quotation, are mandatory exceptions by virtue of Article 17, paragraph 7 of the CDSM directive. So with now effectively a mandatory pastiche exception, and some member states certainly will have to implement it, and I call it a relatively generous interpretation. It's more than I was hoping for. We do have a significant breathing space for artistic creativity. So I simply say that the Court of Justice thought it to be implied that with that ruling, the balance between the right to artistic freedom or artistic freedom in general and the right to intellectual property would be appropriately struck.
Mhm. I want to ask you about the broader significance of this decision, but before doing that, I have another question. I'm not so sure if you can answer, but maybe to give me maybe what do you think, your personal view? Because
Yeah.
you mentioned also before that it's a notion quite important in this ruling. The person familiar with the source work. Okay, it's like it's a notional assessor of pastiche character. How, actually, this is my really question, how
Mhm.
should courts define this familiarity in practice?
Mhm.
What expert musicologist, average fan, something else? And does this standard create some predictability problems
Yeah.
for rights holders?
Yeah, it's a very difficult question. I can't give you a full answer. I can only
Mm,
speculate. So
mm,
I remember that the German Federal Supreme Court, with the first Pelham ruling, which also used this notion of recognizable to the ear,
mhm,
said recognizability in relation to the infringement test has to be based on an average music listener, no?
mm,
A very standard person who, and this already goes beyond the wording of
mm,
the Bundesgerichtshof ruling. Uh, every now and then probably listens to the radio or a randomized Spotify
mhm,
playlist. The interesting question from an evidentiary basis would be whether it has to be a song that is more than obscure in the non-obscure sense, so people know the song in general, or whether it would be suffice that one becomes familiar with the song by having the song played to oneself. But I think this is then something at an evidentiary basis that the courts will have to develop. If we talk about basic pop songs, I think that's the average radio listener, somebody who listens to radio
mm,
in the car or is generally aware of pop music. I think it will become slightly more difficult if you can call them legacy songs, like old songs that nobody knows anymore, but which are still interesting for sampling artists because they have interesting patterns. But of course, this is also qualified by the criterion that the sample has to be characteristic. No? So that I think also implies on the notion of the character.
mm,
If the sample taken is characteristic, or more generally, the part taken, it's not a ruling that's limited to music sampling, it applies horizontally through all art forms. Is the part taken is in itself something that you remember after having recognized it. That
mm,
is sufficient. So I think that character is a fairly standard one.
mm,
That would most likely include every type of popular music, popular art, and so on and so forth. So something that, if you were so minded, you can say it is part of the cultural canon of a society. But for example, if I could be considered to be the average listener of 1970s Greek folk music, I'm not entirely sure.
mm,
So the courts will have to find like a common ground there.
okay, fair enough. So let's go to this to explore also this uh, the possibility, not the possibility, this character, because the ruling seems to have a broader significance. It's not only applied to sampling. It is not only important because we have, after 20 years, we have finally a decision, but not finally, because probably we have also German courts, but this is another case. Maybe I
Yeah.
will ask you later about this. So it's important because we have 20 years. After 20 years, we have a decision. But for the people that also attending, most of them, they're also, of course, copyright lawyers, or they are involved.
Mm.
They know that everybody's mentioning this and so important because it says another significance. Can you a little elaborate on
Yeah.
this?
So also, quite frankly, if you look at the immediate reactions, there are effectively two common themes
Mm-hmm.
that emerge. Number one is what's the effect on licensing markets? I mean, there is probably unbeknownst to many people a relatively vivid market for licensing samples.
Mm.
And the question is, if we now broaden this exception, what will this mean for people who offer licenses for shorter samples that you can use for all types of musical creativity? But this is, of course, musically restricted. One footnote: the cases that the German courts decided on the new pastis exemption before Pelham were not music cases, they were visual art cases. So there will also be a significant relevance for any other type of artistic appropriation. And of course, the colleague of mine calls this always the $1 million question is, what does this mean for artificial intelligence? Because if you think about also in the light of the recent ruling by the Landgericht Munich, the regional court in Munich, OpenAI versus GEMA, what does this potentially mean for the liability of the providers, but also deployers of AI systems, generative AI systems that create outputs in the style of or integrating parts of earlier works? And there, one can even potentially connect these two questions, licensing as well as AI outputs. My guess is the legal practice, there might be one or two initial landmark cases, will not significantly shape this, but I think the right holder and the platform sector will find an economic accommodation, how to factor in now a few more permitted users into their licensing terms. Now, we had already a similar scenario with Article 17 of the CDSM directive that requires certain online platforms to obtain licenses from right holders whose works are being uploaded by their users. And that would have included shorter uses of existing works. This can be relatively simply adjusted by adjusting the licensing fees. So I don't think the sampling market will be eradicated. Pastiche doesn't say you can use everything for free, but it establishes a number of still relatively strict criteria that, albeit, leave flexibility. But there'll be many, many other users that will require licenses, and I think this new flexibility will simply be consumed within larger licensing negotiations. I don't think it's going to change the licensing market significantly. And one can always assume that some people that use samples simply want convenience, legal certainty, and then they might simply be willing to pay instead of facing potential lawsuits from right holders. So structurally, I don't think the sampling markets will change or any other licensing markets. But I think the economic considerations behind the licenses could change. But this is really just my guess. I think we simply have to wait and see how this plays out. But I think for AI developers, it could give them an argument in the now emerging licensing situations in reducing the amount of money that right holders will ask them by saying many of the things that our users create with AI outputs will likely constitute pastiche, whether it's stylistic imitation that copies original characteristic elements. This would still be covered by the pastiche exemption, and there maybe the licensing fees will not be as exorbitant as they might be. But this, of course, is only for the output stage, not for the input stage.
Yeah. Okay. I need also another guess from you. Probably it's a guess. Do you think that this is an intended or unintended consequence, so that the ruling leaves maybe the door open for AI generated works or assisted? I wouldn't say AI generated works that imitate an artist style,
Yeah,
or to qualify as pastiche?
I will indeed have to guess here. I say not knowing the Court of Justice. I'm not friends with the judges, but I'm fairly familiar with the jurisprudence, certainly in copyright law. The Court of Justice, and I said that before, answers the question that it is being posed. It doesn't speculate much into the future. Advocate generals do that, but I cannot assume that the judges did not have that on their mind when they made this decision. Also, keeping in mind that the pastiche exemption is part of the directive on copyright in the Information Society Directive. This is digital copyright law. The German legislator implemented pastiche with express reference to internet users, not necessarily artificial intelligence, but phenomena like memes and so on and so forth. So it must have been on the mind of the judges. However, they were also textually bound by Article 5 of the InfoSoc Directive. So I think they probably knew it. They intentionally did not write it in there because they simply weren't asked about AI. This is then for another ruling that we might expect in the near future, I hope. But it will have been on their mind, and they probably have been very, very careful in designing the formulation of their reply to the German court. But it is always important to recall the objective of a preliminary reference is to assist the referring court to come to a ruling in the light of EU law in the very specific limits of that preliminary reference and not make speculations into the future. So it's probably an act of very, very careful drafting. And of course, you can also again assume that some judges might have had a different opinion. And if somebody wanted to put something on IA in there, which I think probably would have been appropriate, the other judges might have simply said, let's not do it and wait for the case where we're actually being asked how the pastiche might apply to AI outputs. But I think with the ruling that we have on the table at the moment, many AI inputs would be covered because pastiche does not require an intention, but objectively needs to be verifiable by a person who is familiar with the source work. So I think many AI outputs simply will be covered by that definition.
Yeah, actually, this I was thinking when you were talking, especially about the outputs, and gives to the mostly to the deployers, not only another argument, another weapon, because they say, okay, stylistic imitation is not protected by copyright, and they have this, argument. So, but with this case and how pastiche exception is interpreted, they give them more. The case gives the deployers mostly some more arguments to defend that the output that they have created is not infringing the original work.
Absolutely, absolutely. And of course, if you look at this in the wider context of European copyright policy moment, and now I know I'm digressing here now, but many of the listeners will be aware that we recently had the FOSS report, the report by the rapporteur who already gave us the CDSM directive, which stated that going forward, in the light of the ruling by the Munich court, AI deployers and providers should be liable for AI outputs under copyright law. And also that we should find a solution retroactively for infringement in the past. And now if I am a mildly intelligent AI system provider or model provider, I would say, but in the past, we were already covered by the pastiche exemption. So this political discussion on future, but also past infringements through AI system providers will have to be revisited in the light of this ruling. So depending on how we interpret Pelham, this could be a huge relief, at least financially, for AI system providers. One thing that I think is also important here then to mention, not only will this ruling have implications on the question who gets the money in the end, but this ruling should also be very relevant for the question, are AI system providers, AI model providers, required to have pre-installed filters in their system that preempt infringements, very, very similar to the mechanism of Article 17 of the CDSM directive. Now, because if these users are lawful, and if these users are an expression of artistic freedom, or more generally freedom of expression, no AI system, but also no online content sharing service provider in Article 17 should be inclined to filter or to monitor or to block outputs that are actually in conformity with the pastiche exemption. So I think there'll be a number of discussions on how to implement the ruling, but I think the direction is relatively clear. Much more artistic creativity, derivative artistic creativity is now possible. And one could potentially even argue, and I'm very, very careful, I think I'm on very thin ice, we might be at a point where the Americans are looking relatively jealously at us, at least in the domain of artistic creativity. That this is indeed an artistic license, limited, however, that provides a bit more breathing space, unconditional breathing space, potentially limited by the three-step test, of course, for reusers of existing material. Could you switch on your microphone?
The use of the three-step test is another big issue. I'm not going there now, at least. Maybe there are also some questions from the people that they attend, the attendees. But before giving the floor to them, if they have questions, if they don't, I have plenty more to ask you. I want you to tell me that the ruling will now go back actually to the German courts, which will finally settle the dispute. Yes. What do you think will be the outcome?
I always dread these questions. Of course, I don't know. My guess is, with all the history and the strong reliance on fundamental rights, on constitutional values in this case, the decision will tilt on the question of whether the sound of two sheets of metal clashing against each other is characteristic of the original work. I think this is the breaker in this specific case, because the Federal Supreme Court had already said in Germany that the sample is recognizable. You can hear it through this recognizability test under the phonogram producer's right. But I think by the same token, it is recognizable for the purpose of pastiche. The question is this a characteristic part of Metall auf Metall, the original song from which the sample was taken? I'm not an expert in this music genre, I have to be very frank with you, but having listened to the song, as you can understand, a number of times, I think it is characteristic. So that means, I think, after 2021, the use of that sample is lawful. With the very, very weird outcome that the use was lawful before 2021, before 2001. Between 2001 and 2021, it was unlawful in Germany, not in other countries who had a pastiche exception. And with the introduction of the pastiche exception, it has become lawful again. And permit me this intermission. You raised the question before, at least implicitly. There are arguments that would suggest that member states are actually obliged to implement the pastiche exception. So if I had nothing to do with my time, I would ask somebody to bring the lawsuit to say whether member states are required to permit certain or to actively implement certain exceptions from Article 5 that are reflective of fundamental rights. There is an illusion in the case law of the Court of Justice, Pelham von Spiegel Online, that this could indeed be the case. So I think there are even strong arguments that what Pelham had been doing was lawful from 1997 through to effectively today. But that's then a question for another day. So there might, I don't think there will be, but there could be a third case before the Court of Justice on Pelham on this very, very unique and I think largely academic question.
Okay, thank you. Before monopolizing also you, maybe I would like to ask whether there are some questions, a question from the attendees that would like either to post it on the chat, or also I think there is a possibility to ask yourself. If there is not any, I have really a couple of questions because I think it's quite.
There's one raised hand, yeah.
Yeah, I'm trying to. Janos. Jano, can you have the. Just a moment. I'm trying also to see whether he has.
He has no access to the microphone, so he probably has to type the question.
Yeah, I think we could also give me, but Jan is from our copyright, but in the meantime, trying to find out whether Janos has access to the audio too. I think from the copyright office there is one question, and here I'm sure that we can listen. I know Maria, who wants to ask something, or Eva.
Hello, good evening.
Okay.
We are here from the legal department of the Hellenic Copyright Organization attending this webinar. Thank you very, very much, Professor Jütte. I would like to clarify two just things. I am sure that I understood well that you consider that the pastiche exception is now without any limitations?
When I say without limitations, it doesn't mean you can use everything as long as the substantive requirements are complied with. That's a pastiche, but I don't read in the ruling that there is a requirement that you cannot take more than necessary. And this is what I mean with artistic license, that quotation is limited by proportionality. You should only quote as much as is necessary. We simply don't find this in the Pelham 2 ruling. And there, I'm fairly optimistic to say, if it's not in there, the restriction doesn't exist.
Okay, so there should be some limitations to be considered, because otherwise we may consider, or many infringers could consider that since there is a relevant also theory here in Greece, that if we take 3 or 4 or 5 seconds of a musical work, let's say, it could be lawful. So the pastiche now exception, as it had been interpreted by the Court of Justice, does not mean that we can use anything anywhere for any reason and purpose, right?
Yeah. Well, again, I refer to the student requirements. We have to take a part that is characteristic in order to establish an artistic or creative dialogue, which then burdens the courts with the question to determine whether a specific use is an artistic or creative dialogue. The German courts seem to have suggested that the use of a different style of music, and this is sampling, music sampling limited, the use of a different style of music to integrate this into a different style of music creates this type of dialogue. But how we interpret this notion of an artistic or creative dialogue, it has to be artistic or creative. And don't even ask me how I interpret what is an artistic or creative dialogue. This must be there. It is limited to artistic engagement with an original work by taking a characteristic element from that. But beyond that, I don't see any other criteria. And it is also permissive in the sense that, yes, potentially a 5-second sample is permitted, although in principle, to achieve the dialogue, a 3-second sample could have been sufficient. It should not go as far as to say that a plagiaristic appropriation should be allowed, because then it would be difficult to establish this type of dialogues. There has to be a balance between the original and the integrating work to enable this, if you will, conversation, engagement with each other. But I think this notion of an artistic dialogue in the light of fundamental rights to achieve the object and purpose of pastiche has to be interpreted relatively liberally. So no quantitative threshold, but there are the requirements, of course.
Okay, and then can I just give me a few more seconds?
Sure.
So this is the exception that should be protected in that way in terms of freedom of arts, the fundamental human rights, the dialogue, the inspiration, the promotion of creativity, and so on. How this is related, then I'm sorry if I'm being a little provocative, with AI outputs. I mean, since it has been frightening me a little bit that AI developers should have right now, could or would have right now such a weapon in their hands against authors and related right holders.
Yeah, I do agree with you, but I think there's a relatively simple answer to it. If we understand AI not as a purpose in itself, but as a tool for creatives. So if you enable individuals to use AI to generate outputs, that is effectively an artistic activity. It's just a tool that we might or might not agree with from a cultural perspective, but it is, Advocate General Spooner in the first Pelham said, it's the modern paintbrush. Spooner had a crooked analogy, and I used the same crooked analogy, that sampling is nothing else than the paintbrushes and the colors for the painter, a palette of working material to create something new. In the same way, AI systems, certainly generative artificial intelligence, are tools for individuals that are made available by companies to be artistically creative. And AI systems don't generate outputs, at least most of them, without any user input. And this is why I think there's a good argument to say everything that comes out of an AI system that is directly prompted by a human being. The question is how precise the prompts, of course, have to be. This is in principle protected by Article 13, whether you like it or not. No, I fully understand your reservations, but I think AI puts benefit from the same copyright exceptions that people creating without AI would be able to benefit from.
I think now Janos, Mr. Paramithiotis, has possibility to ask himself. Janos, you have the floor. Yes.
Okay. Hello, everybody. Thank you, Professor Jütte, for this analysis and for giving this lecture. So you mentioned earlier that the Americans might be jealous of the Europeans after the Pelham 2 decision. This struck me like I want a slight clarification on that. Does this mean that you see that the pastiche exception gives more flexibility than the very fair use doctrine in light of this decision?
Yeah, I shouldn't have made that comment. I know it's certainly not more flexible, but I think if you look into the recent a few years ago, Supreme Court ruling in AWF versus Goldsmith, the Andy Warhol ruling. The Supreme Court introduced this competition thinking, displacement thinking in the fair use analysis, which allegedly had always been there, but it simply said, if you create something, or if you use an existing work in a creative way, it is not fair use if the work operates on the same market, and we don't have this limitation.
Substitutes.
Yeah, unless we bring in the three-step test, then we could make the same argument. But without the three-step test, I think at least we don't have this express market substitution argument that the Supreme Court used. On the other side, if we take it pessimistically, we say the American fair use doctrine is still much more flexible in relation to artistic uses, which I don't think it is anymore. We're moving closer to that, certainly, with this relatively flexible artistic exception. It will not apply to non-artistic uses. Now, pastiche clearly is an artistic and creative use that has to be demonstrated. We cannot apply pastiche to AI training, for example, where the Americans are probably much more liberal than we are.
And can I have one more question, please?
Sure, yeah.
Yes.
Do you think that the judges of the Bundesverfassungsgericht are like saying, we told you so, guys, we told you so, and you needed to go to the CJEU twice?
Yeah.
We told you so.
Yeah.
Of course, not invoking a pastiche exception, but doing the whole balancing test with freedom of the art and freedom of expression.
Yeah, I don't. They would never say that this way, obviously, but I think the Federal Supreme Court and the lower Hamburg courts were very much bound by the letter of the law, and it was really the introduction of the pastiche exception that created a fresh opportunity to make this argument. I think the the Constitutional Court was already quite happy with the Court of Justice's interpretation of the scope of the sound recording, because you can address artistic creativity from either side, related and copyright, or exceptions. You could always argue that there wasn't sufficient freedom, but at least there was sufficient freedom to come to an agreeable balancing of fundamental rights. So I don't think that the Constitutional Court would have said, we knew it all along, but maybe they might have had a certain influence in pushing legislative interventions. Now, one thing that I always think is very, very important, which Pelham doesn't necessarily do, is that we clearly message to non-copyright experts what is permitted with pre-existing creativity. And I think the fact that we now have an artistic pastiche exemption is much, much better in this legislative messaging for specific users. That was missing before. And I fully agree with you, there is now a slightly different balance, but whether the balance prior was unconstitutional, I wouldn't be entirely sure. Art-minded judges might simply be happier with the ruling. That would be my hopefully diplomatic answer, but I have no ambitions to be elected to the German Constitutional Court.
It was not a literal question. Thank you.
Thank you for the question.
Does anybody else want to ask something? I don't see any hand raised, but given we have 4 minutes, I want to take advantage of you. Last question from me.
Go ahead.
Please. Because from what I understand, there is a case-by-case approach almost mandate by the court. And you mentioned very, let's say, nicely that there is also this sampling licensing market. Is there a risk that this sampling licensing market that does exist will be fragmented across member states because national courts will implement differently this criteria of artistic dialogue that's very poetic, again, I'm repeating, but very, very general, very, very wide. So, yeah.
It's an excellent question. I don't think so. But let me try to expand a bit. One thing that I expect is that national courts will now listen very, very carefully to what their neighbors or other domestic courts in the European Union will be saying. I think they want to avoid that there is a significantly different understanding of pastiche. it is not avoidable that there will be rulings that would have been decided differently in other countries, but I don't think that this will have a significant effect on, I'm quite not sure if it exists, on the unity of the sampling market. Yeah, this is probably the best answer I can give without saying something utterly stupid. But I think there will be a convergence of this notion of pastiche. Worst case, it has to go back to the Court of Justice. We will now have I can say that as a German, a relatively well-known court in Germany giving the final ruling in one of the longest pending cases before in copyright law on what constitutes pastiche. And I think all the other courts will look very, very carefully. If there then is a court that says we have a fundamentally different understanding, my guess is this will end up before Luxembourg, and then I'd be pressed to give you a qualified answer, say what else could the Court of Justice say without taking the flexibility away that it has given with this ruling. But I think it is important to state that we need this flexibility because art changes, culture changes. So we cannot pin this down, and this flexibility inevitably will also result in not contradictory but nuanced understanding of what constitutes pastiche. But we simply will have to see. I don't think it will end up or will have catastrophic implications for the licensing markets in terms of fragmentations, in terms of erosion. Actors will simply adapt. It is an interesting ruling. It is a landmark ruling, but it is not a ruling that changes everything in copyright law that we know.
Mm-hmm. There is a last question typed in the chat. It's from Mrs. Vasiloyanaki. And she's asking, according to dictionary definitions, the term pastiche is connected to imitation of the original work as homage or celebration to the last.
Yeah.
It is not supposed to be just a copy. Do you believe that under the ECJ decision, there is a room to interpret a pastiche just as a right to copy an original work? Is the artistic dialogue a reference to the connection between the works included in the definition?
Okay, so we have 1 minute left, so I but I have to make one.
Nobody will,
Good, excellent. I have to make one detour. So
Yeah.
if you read certainly the Advocate General's opinion, but also the ruling, and I mean I've also written with colleagues from various countries and analysis of what actually is understood as pastiche. Across the member states, there was no uniform interpretation of what is pastiche. And this is where the Court of Justice said we have to find our own definition, which is partially based on existing interpretations, but it is also now an autonomous concept. But it clearly says there has to be an artistic dialogue between the work that uses, in this case, the sample, and the work from which the sample is taken from. So I think we have to detach ourselves from our former national understanding of what constitutes a pastiche and simply have to adopt this new European definition in the same sense we did with parody and any other exceptions, or the phonogram producer's right that the Court of Justice interpreted in a European understanding. It is not a right to blatantly copy. That would not be reconcilable with our understanding of artistic freedom. And we had discussed this before, that there's also this weird passage in the ruling that disguised uses or uses that are not obvious are not covered by the pastiche exception. So it has to be a visible, in brackets, paraphrasing, active engagement with the source work in form of an artistic dialogue. So blatant copying, absolutely not. We need this artistic engagement. And this is why it's protected by freedom of the arts.
Thank you. I think at this point, we will thank you very, very much for your time. I think you devoted to us the most valuable thing, time, and also the Adedins have devoted their time to listen to you. And thank you very much. It was very enlightening and very useful and informative. I liked it very much. I enjoyed it very much myself. I hope also the attendees. And stay tuned because the next Global Talks, Series 4, will have Ted Shapiro talking about the like case and common in the ECJ. So thank you very much, Professor Jütte.
Thank you.
And till the next time. So bye-bye.
Bye-bye.
Bye-bye.